Okay, welcome everybody to another Friday morning where Stonehill is committed to offering agents enough CE credits that they can get all of their CE credits, the requirements for free. And we do that on Sunday mornings at 10 o'clock. Whether or not you are associated with Stonehill, we just appreciate your participating. We'd like to have everybody be part of the community and feel like they're welcome in the community here. Today we have our good friend John Maurer from Mountain CE Insurance Training. He comes on and he does trainings for us on a regular basis. He did one several weeks ago, and he's done this one. And it is an attempt to try to enable you guys to feel comfortable answering both the specific and the general questions that your beneficiaries or your clients may have. So without further ado, John, how do you want them to manage their questions? Should they ask you during the presentation? Should they wait to the end? How do you want to do that?
I encourage questions. I encourage discussion. Typically when we have a large group like this, it's good to ask questions through the meeting chat. So if someone at Stonehill can monitor the questions that come in through the chat feature, that'd be good. And then every once in a while, I'll pause and ask if there's been any questions that came in through the chat. So that's usually the way it works. But if somebody really has a burning question and has to be answered right now, it's okay to turn on your microphone and ask the question, but it typically works best for them to come through chat.
Okay, I'm going to be monitoring the chat. Usually Nancy does too, so thank you.
All right, thank you, Doug.
Take it away.
All right, welcome everybody. My name's John Maurer. With Mountain CE, my wife and I, Marlene, own Mountain CE. We've been doing this for 21 years now, and what we do is pretty straightforward. We help people pass the state insurance exam, and we also do continuing education for insurance agents. And so this class is going to be 2 credit hours, go from 10 o'clock until 12 o'clock, and it's specifically for Utah resident producers. We delivered this class, the same class for Stonehill, a little bit more than 2 years ago in February of 2026. So even if you took it with us 2 years ago through Stonehill, most likely it's going to count again for this current license period. So the key here is if you're in a new license period. If you're in the same license period as you were 2 years and 1 month ago, then it wouldn't count. And the only reason that would happen is if you're a new agent and your original license period was longer than 2 years, then it wouldn't count again. But probably it does, even if you attended 2 years ago. So let's go through the things that we're going to talk about this morning with the work comp. I know I forgot to mention, we'll take a short break, just a quick stretch break, about 5 minutes, about halfway through at 11 o'clock. Or somewhere around there, just a quick one though. So we're going to talk about the importance of workers' compensation, the purpose of workers' compensation insurance. We'll go talk about things like the legal doctrine of absolute liability and also the legal doctrine of exclusive remedy, what that means. We'll talk about state laws. So work comp insurance, as well as other types of property and casualty insurance, is heavily regulated by the state insurance department, not so much the federal government like health insurance is. So we'll talk about state laws, like things like what are compulsory laws, what's selective laws, what's competitive mean, what do we mean by monopolistic, which workers are covered by work comp. Talk about the fact that employers can self-insure for work comp in some cases. Talk about what the WCF is, who has to buy work comp, and specific coverage for small business owners, and what the coverage waiver is for contract workers. We'll talk about which benefits are provided by work comp, like medical care, rehabilitation, disability income, death and survivor benefits. We'll talk about the policy parts. There are 6 parts of a work comp policy. And that's really the things we're going to go through this morning. So I want to bring up here a document that I think is critically important. Oops, I pushed the wrong button. There we go. So this document comes from the Utah Commission, the Utah Labor Commission. So it's a really excellent document giving us in plain language, in terms that even I can understand, about what employers need to know about workers' compensation. So if you are new to workers' compensation and you want to have the basics down when you're talking to your clients, I would encourage you to find this document. It's easily available on the Utah government website. It's called Employer's Guide to Workers' Compensation. You could Google that and easily find that. And it's in a PDF format that you can print out. You can refer to at any time. So we're going to go through first a couple of important things that are in this document. First of all, what is workers' compensation insurance? And really important thing about work comp is that it's no fault insurance. So what do you mean by no fault? Does that mean that nobody is at fault for anything? That doesn't really mean that, but it means that when it comes to a worker getting hurt on the job, we don't care whose fault it was. It doesn't matter if it was, and I'm talking in general terms here, there's always exceptions to these rules, but generally speaking, it doesn't matter if it was the employee's fault that he or she got hurt, or the employer's fault, or a coworker's fault, or nobody's fault. Doesn't matter. Work comp pays if a worker gets hurt. Also, work comp not only covers workplace injuries, but also illnesses that are directly related to that job. And it can be reasonably attributed to the fact that person got sick, got ill because of the work. So workers' compensation is known as the exclusive remedy. I'm going to highlight those words, exclusive remedy. And exclusive remedy means, the word exclusive means only. It's the only remedy that our system has. Our society as a whole relies on workers' compensation insurance to take care of workers who get hurt on the job or get sick from their work. Exclusive remedy means only remedy. In other words, if I get hurt at work, I don't have to sue my employer to get benefits, to get my medical bills and my rehabilitation and so forth paid for. I don't have to sue my employer, and pretty much I can't sue my employer. So there's a trade-off. I don't have to sue my employer, but furthermore, I can't. It really doesn't work. I mean, again, could be exceptions to the rule, but for the most part, if I get hurt at work and I call up an injury attorney and say, hey, I got hurt at work, can you represent me and get me money? And then the attorney's going to say, sorry, but yeah, it's not going to work that way. You got to go through workers' compensation insurance. Another legal doctrine we say about workers' compensation is that it's considered, workplace injuries are considered to be absolute liability. Again, that term is absolute liability. And what's that mean? Absolute liability means that it's a situation where somebody is automatically responsible, automatically liable. It's another example of that would be like, let's suppose somebody gets hurt playing in my backyard on my pickleball court, and they sue me. It could be that even though there's nothing wrong with having a pickleball court, even there's nothing wrong with encouraging people to play on the pickleball court, somebody gets hurt, they could maybe sue me and recover based upon this idea of absolute liability that, well, pickleball is dangerous and having a swimming pool is dangerous, having a trampoline is dangerous, and if somebody gets hurt, somebody's got to pay. And so that's the way it works with workers' compensation insurance. There's absolute liability. The employer is automatically responsible. All right, any questions so far? I know we've just been talking about high-level fluffy stuff so far, but have any questions come in so far?
Do workers' comp have any value for someone self-employed?
So the question is, if I'm self-employed, do I need workers' compensation insurance, or should I get it? Do I have to buy it? We'll talk about that in a moment. That's a great question. So yeah, we will address that in a bit. All right, any others? Okay.
Nope, that's it.
All right, so sometimes people get mixed up between unemployment insurance and workers' compensation insurance, and they're, two totally different things. Unemployment insurance is when somebody gets laid off from the job and they can collect unemployment benefits, and workers' compensation insurance is specifically related to workplace injuries and illnesses. So two totally different things. Let's see. Oh, there's some questions over here. So are employers required to provide workers' compensation insurance coverage for their employees over here on the left? And yeah, pretty much all employers have to buy work comp insurance. There are some exceptions to that. And so which ones don't have to get work comp or be covered by work comp? And so they're listed here. For example, sole proprietorships. So this goes back to the question just a minute ago. If there's a small business owner and there's just one person doing the job, the person has no employees, like say there's a painter who does painting, no other employees, that individual does not have to buy work comp insurance. Not a requirement if the sole proprietor does not have any employees. Typically, partnerships don't have to buy work comp. Also, limited liability companies in which the owners perform all the work and have no employees don't have to have workers' compensation coverage. All right, so I think that answers the question we had just a moment ago. If not, let me know. But I'm going to give you a real life example here, though. So here at Mountain CE, the company is owned, so it's an LLC. There's two owners of the company, two members, we say, of the LLC. It's my wife and I. But we have work comp insurance. Why? Because we are, for our tax purposes, for tax purposes, we are considered to be a S corporation. When we do our tax return each year, it's an S corp filing. And in order to do an S corp filing, the IRS recommends that the IRS says that the members need to be employees of the company. Why? Because then we're forced to contribute to workers to have FICA paid to fund Social Security and Medicare. So even though my wife and I own the company, we run the company, we do have contract workers, we don't have any other W-2 employees, we do have work comp insurance because my wife and I are W-2 employees. So that when you're doing an S corp, that's the way the tax advisor said we had to do it. Okay, so it's complicated sometimes, it's tricky, so always want to talk to a tax advisor to make sure that we're doing things right. All right, any questions there? But generally, small business owners don't have to have work comp insurance if they don't have any additional employees, but for tax purposes, sometimes you do need to have employees anyway. Yourself has to be an employee, especially if it's an LLC. Another question that sometimes can come up is, can employers put the burden on the employee to fund or to pay for the work comp insurance? And the answer is no. It's different than with health insurance, right? With health insurance, the employer can pay part of the premium, the employee can pay part of the premium, but with work comp insurance, the employer is required by law to pay for it 100%. Okay, we already talked about the unemployment insurance question. Another question is, what are an employer's options for buying work comp coverage? So in Utah, and it works differently in other states. Not all states do it the same way, but under Utah law, coverage can be purchased from the Workers' Compensation Fund, also known today as WCF. They legally changed their name a few years ago to WCF. So originally, many decades ago, the Workers' Compensation Fund started, and I understand it was a public entity. In other words, it was state-run, state-owned and state-run. And throughout the years, it evolved now into not being state-owned anymore. It's no longer state-owned. It's no longer state-run. It's a mutual insurance company. But WCF is still different than other insurance companies in the fact that WCF is known as the insurer of last resort. I'm going to highlight those words. Insurer of last resort. So suppose there's an employer and it's high risk job. Like it's the employer runs a circus and they have all kinds of dangerous animals and dangerous things, acrobatics and so forth. And it's really difficult to get work comp insurance because no insurance company wants to insure that situation, lots of danger in the job. WCF has to take everybody. All employers who apply for work comp insurance have to be allowed to get it if they want to get it from the WCF. Insurer of last resort. But there's many, many other insurance companies that sell work comp insurance that are allowed to sell work comp insurance as well. And so if an employer wants to get it from a different insurance company, they can apply for it. But the other insurance companies can have more strict underwriting and don't have to take everybody. And last time I looked, the WCF has about 50% of the market share of workers' compensation in Utah. So pretty big, pretty significant part. Another thing that an employer can do is to self-insure. But only big companies, big employers that are very financially sound can self-insure. They have to apply with the state. They have to prove that they have a certain number of assets. They have to prove that they have a certain amount of money set aside to pay for claims. So it's my understanding that there's not a lot of companies that do self-insurance, but it is a possibility. All right, I'll pause there a moment in case anybody's got any questions or concerns.
Yeah, so Gene says you may address this later, but the cost of workers' comp is based upon the inherent risk associated with the specific occupation. So not a question, but a comment.
One moment. I'm gonna plug my headset in here. Okay. Okay, can you all hear me now?
Yeah.
Okay, so I'm sorry, Doug, could you mention that comment once more?
Yeah, Gene makes the comment, you may address this later, but the cost of workers' comp is based upon the inherent risk associated with specific occupation.
Yeah, of course. Yep, that's it is something that we'll talk about towards the end of class. And so there's really three main factors that go into how much work comp policy is going to cost. One is the inherent risk with the job. So a construction worker is a construction company that has construction workers is going to have a much higher premium than a similar sized company that does only office work. And then another factor is payroll. So the bigger the company, the more people that are working, the bigger the payroll. That's a factor. And then another factor is also experience. So employers that have a good safety record in the past are going to pay less than employers that have had more injuries. Yep, very true. Anything else right now?
No.
Okay. So another question about here's self-insurance again. Just a reminder that some employers are allowed to self-insure for work comp, but there's not very many that do that or can do that. So a question that comes up is what if, and so work comp is regulated by the states. And in order to, if there's a Utah employer, if that Utah employer has employees in Utah, the policy has to be specific to Utah, following Utah laws. So then the question is, what about if a worker works somewhere else for a while, temporarily? And so generally speaking, it says Utah employees working out of state for less than 6 months are covered by their regular employer's Utah work comp policy, but the employer can extend the 6-month period by filing notice with the Utah Industrial Accidents Division. If the employee is permanently stationed in another state, the employer must comply with work comp coverage in that other state. Here's a really important thing. Can an employer pay for an injured worker's medical bills without going through work comp? And no, that's illegal. So it'd be highly illegal for an employer to say to the employee, oh, looks like you need to go to the hospital. Well, we'll take you to the hospital. When you get there, tell them that you fell off a ladder at home in your garage, because we don't want this to go through work comp, because if it goes through work comp, then our premium's going to go up, and we've already we're paying too much already for work comp. So let's just keep this between us, and we'll take care of your injuries. No, that's prohibited by law. We talked earlier about the fact that not all employees have to be covered by work comp. Here's some that don't. Some agricultural workers. So it has to do with the size of the farm, the agricultural operation. So small farms that employ workers don't have to buy work comp insurance for their farm workers. Some casual or domestic workers. So like, let's suppose that a babysitter comes to my house every day to take care of my kids. Probably don't have to buy work comp for that babysitter. Or I hire somebody to fix the roof on my house. Don't have to buy work comp insurance for that. So it's the kind of the general rule with who has to get work comp or which employers. If it's a regular course of business where the employer has a real business making money, then generally got to get work comp. But if somebody does work around the house, I'm not hiring somebody to help me make money. I'm just trying to take care of a thing that needs to be taken care of, or take care of my kids. Don't have to buy work comp. All right, another exception is some real estate and insurance brokers don't have to be covered by work comp. So if you need more details on that, you can refer to state law. But why is that an exception? I'm guessing it's an exception because when this law was created, there were probably legislators debating the law that were real estate brokers, or insurance brokers, insurance agents, whatever. And they put that in there so that they didn't have to buy work comp for their employees. I don't know, just a speculation. And then, as we mentioned, sole proprietors, partners of a partnership, and members of an LLC don't have to get work comp. But I did mention the exception, to the exception for limited liability companies where if a member of the LLC is getting a W-2 wage, then yeah, technically you should get work comp. All right, so while these types of workers are not automatically covered by work comp, their companies can choose to provide coverage for them. All right, any comments or questions at this moment?
Yeah, so Craig Pendleton asked, does it have anything to do with 1099 employees?
So yeah, that's question number 16 here. What's the status of independent contractors under the work comp system?
So I was just wondering if the exclusion for insurance agents and real estate agents had anything to do with the fact that they're 1099.
Oh, I see what you're saying. So are you looking at it from the worker's point of view or the employer's point of view, like the insurance company's point of view?
Well, you just stated that workers or insurance agents and real estate agents weren't required to carry it. So I wondered if that was a factor of being 1099.
Yeah, I think that's part
independent
of it.
Contractors.
But also, you know, like let's say there's an office of 5 people, and an agency, an independent agency or exclusive agency, doesn't matter. I'm thinking that, yeah, the insurance company doesn't have to, if that office already has work comp insurance, then the insurance company doesn't have to get work comp for that office. But if the office itself is an employer and employs people, then the question would become, does that agency need to buy work comp insurance for the employees?
Yeah, that would be different. Yeah, that makes sense. Okay.
So then, yeah, I think that we'd have to dig further into law and see what the exception is. So, so I don't have all the laws and the rules memorized for everything, but I will write that down and see if I can. Okay. All right. So what's the status then of independent contractors in the work comp system? So in order to qualify as an independent contractor, a business must be independent in its work and not subject to control and direction of some other entity. So independent contractors are treated the same way as any other business. If it has employees, it's required to obtain work comp coverage. But if the independent contractor, like a painter or an insurance agent that gets a 1099, but if the independent contractor does not have employees, it may be eligible for work comp coverage waiver. So all employees, all workers have to be covered, but if there's a contract worker with no employees, then there's a waiver that can be applied for. And I think it mentions it here. See, I'm not finding it, but let's say that so the employer that hires a contract worker doesn't have to provide work comp insurance for that contract worker if that contract worker or workers has their own work comp insurance. But the one who hires the contract workers should get evidence that they have their own work comp insurance. And if they don't have their own work comp insurance, then that contract worker should provide a waiver saying that they don't want to have coverage. Okay, here's, I think we touched upon this earlier. Must injuries be reported only if they require first aid? And we said earlier that if somebody needs medical treatment, then that has to go through work comp insurance. But what if somebody gets a cut and we can fix it with some antiseptic and a Band-Aid? You know, first aid that does not have to, it says here, injuries requiring only first aid treatment, either on site or at an employer-sponsored free clinic, do not have to be reported. And so where do you draw the line? So there's specifically rules to follow on that. All right. All right. Any questions that you can think of?
No.
Okay. So you're going to be, in order to be able to get credit for this course, you're going to, at the end of the course, you're going to be asked some polling questions, they're called. And so I'm going to give you, along the way here, I'm going to give you information so that you can get those questions right. So for example, one's going to come up here. Whoops. So work comp is the exclusive remedy for employee work-related injury or illness. What does that mean? So, this isn't a, if you get it right, you're going to get credit for the class, or if you get it wrong, you're not going to get credit for, but this is going to be a question that you're going to be asked later on, and hopefully later on you'll get it right. So what do you think the answer is? What do we mean by exclusive remedy? I'll let you read through those answers, and then you can answer it in the meeting chat, what you think the right answer is. You can either, so you can do 1, 2, 3, or 4. You don't have to write out the whole answer. What do you think the answer is? All right, I'll give you a minute or so yet, or not a minute, but a few seconds. All right, so work comp is known as the exclusive remedy, and it means number 4, work comp pays benefits defined by state law to the employee. So if you ever look at a work comp policy, it's pretty short, it's pretty simple. It just says that work comp is going to provide benefits provided by state law. So it's a lot different than other insurance policies. It doesn't go through all the things that are covered, what's not covered, and doesn't go through coverage limits. It just says we're going to pay whatever state law says. And the employer doesn't have to sue their employer to get reimbursed for injuries, and furthermore, generally can't sue the employer. All right, thanks for doing that. Much appreciated. All right, so now I'm going to go shift gears a little bit. So work comp, I'm going to make this bigger so you can see it. One moment while I get the technology working. Okay. Should be popping up. Oops. Okay. All right, so let me know if you can't see that, but it should say before workers' compensation. So just a little bit of history. It's kind of interesting. So work comp insurance is a relatively new thing. I guess you could say a new idea. It started in America in the early 1900s. Specifically, the first work comp policy sold in America was in 1911, just when I was a young boy. And coincidentally, this is true. What I'm going to tell you here, work comp insurance was started in the city I was born in, which is Wausau, Wisconsin, is where the first. Why is that important? I don't know, not really, but that's where work comp started in 1911, the first work comp policy in America. And it was very important because before that, there's lots of factories in the 1800s and early 1900s, lots of factory workers, and the conditions weren't always all that safe. And lots of railroads being built and trees being cut down and so forth. And there wasn't a really good system in place to take care of workers who got hurt. And furthermore, there's a whole bunch of people immigrating into America, specifically a lot of people coming from Europe, looking for jobs, and workers were kind of expendable, you could say. So John gets hurt in the factory. Okay, too bad, too sad for John. Who's next? Who's next in line to take this job? And so that wasn't a really good situation. A lot of people were injured, hurt, died working, and wasn't a good system in place. So that all started to change in the early 1900s when states started implementing workers' compensation insurance. And it's evolved a lot throughout the years, but today it takes care of injured workers, and the system says, doesn't matter whose fault it was or nobody's fault, the injuries will get taken care of. Let's talk about, we already talked about this stuff. Let's go through what the difference is between compulsory laws and elective laws. So nearly all states in the US have what's called compulsory laws. In other words, employers are compelled, they're forced to buy work comp insurance, as we talked about already. So Utah has compulsory laws. And most states do. There's one state, as far as I know, that doesn't have compulsory laws, and that state is Texas. And in Texas, there's what's known as elective laws, which means that the employers get to elect whether or not to buy work comp insurance for their employees. But the trick, though, is that in Texas, if a worker gets hurt, and if the worker gets hurt and the employer doesn't have work comp insurance, the employee can sue their employer. And in most cases, the employer is going to lose that fight and be required to pay for the worker's injuries. All right, so a big takeaway here is that Utah has compulsory laws, not elective laws. Also, Utah has a competitive market for work comp insurance. And that's not the way it is in all states. In some states, about a handful of states in the US, it's a monopolistic system. Monopolistic meaning that there's only one company that sells work comp insurance. There's about 5 or 6 states that have a monopolistic system. And in those monopolistic states, employers have to buy it from a state-owned and operated work comp fund. And that fund has a monopoly. But Utah, like most of the states, have a competitive market, which means, of course, different insurance companies can compete for the business. So even though WCF still has the biggest share, about 50%, there's many other insurance companies that also sell work comp insurance. And what was that term again that we used to describe a situation where if if an employer can't buy insurance from a particular insurance company and they're having trouble finding insurance, there's one place they can go to get it. What was that term called again? Anybody remember? The insurer of what? WCF is the insurer of what?
Last resort.
Yep, thank you. Yep, WCF is the insurer of last resort. So even though we have a competitive market in Utah, there's a safety net for high-risk employers, WCF, which is now a mutual insurance company. All right. All right, let's do a couple of quiz questions. Oh, we mentioned about self-employed. Let's talk about this too. So in order for an employer to be self-insured, got to fill out an application, send it to the state, got to have been in business continuously for at least 5 years, and demonstrate sufficient financial strength. And you have to prove that the applicant is covered by specific aggregate excess insurance. So we got to have like a safety net in case that the losses exceed a certain amount. Then there's a safety net in place, and have to have a surety bond, a minimum of $100,000 issued by a corporate surety to back up their promise to pay for work comp claims. All right, let's talk about some quiz questions here. So it's a chance for you to participate and answer through the meeting chat. Which following is not true regarding states that have compulsory laws? So there's 3 things listed here that are true. Number 1, states with such laws do not allow employers to self-insure. Looks like that might be the false one. Second one, these laws require employers accept responsibility. That's true. Only one state does not have compulsory laws. That's true, Texas. And these laws generally require that employers get work comp insurance for nearly all workers. That's true. So number 1 is the false one. Excuse me. All right. So number 2 says, instead of buying work comp, if a Utah employer wishes to self-insure, it has to do what? So provide a letter, provide a surety bond, get approval from the NAIC, follow the procedures established by the federal government. So you can answer again 1, 2, 3, or 4. All right, yep. Got to provide a surety bond issued by the state of Utah. And the bond essentially backs up the employer's promise to pay for work comp claims out of their own pocket. Number 3, which following is not true regarding the state with elective work comp laws? So number 1, if the state with elective work comp law, in the state with elective laws, an employer can be sued. That's true. Number 2, in the state with elective work comp laws, it's the common law defense arguments are often used by employers to avoid being sued. That's not true. So what would be a common law defense? It'd be like contributory negligence, like if the employee participated or contributed to their own injury, was responsible for his or her own injury, then, why should the employer pay for this? If the employee was responsible partially or fully for their own injury, why should the employer pay? That's what we mean by a common law defense known as contributory negligence. And so the point of this is that in Texas, with elective work comp laws, the employer cannot use those common law defenses. So this statement, though, is saying are often used by employers to avoid being sued. That's false, because Texas, the employers can't use those arguments, and they can be sued, and quite often they're going to lose. So number two is it. Number two is the wrong answer, which is the right answer, because we're looking for the one that's the false statement. In most states have a competitive market for work comp. That means an employer has to do what, or can do what? 1, 2, 3, or 4. Okay. Yep, a lot of you said number 4. Good job. Competitive market means that an employer can buy it from any insurance company that sells it, WCF, or many other insurance companies. Number 5, which statement is not true? So there's 3 things that are true. Number 1, in Utah, some real estate brokers and insurance brokers do not need to be covered by work comp. That's true. Number 2, in Utah, some agricultural workers and some casual domestic workers don't have to be covered by work comp. That's true. Number 3, in Utah, an employer that needs work comp can buy it from any private insurance company that sells it. That's true. And number 4, of course, is the false statement, which is the right answer. In Utah, all businesses must buy work comp. There's no exceptions. There's always exceptions. So that one is false. Number 6, in some states, work comp has to be purchased from a state-run entity that owns the entire state's market share. What term is used to describe these states? And I just did a quick Googling of which states are monopolistic, and it looks like state of Washington is, and Wyoming, and North Dakota, and Ohio. So I guess it's less than a handful of states. Only 4. All right, so monopolistic. If an employer wishes to self-insure its work comp obligations, it must do all the following except which one? So just to give you a hint here, I think a couple of you answered wrong, and then a whole bunch of you followed suit and answered wrong as well. So take a relook at that one. Yeah, a whole bunch of you answered number 3, which is not the right answer. So there's 3 things that are true. I have to complete an application for self-insurance and submit to the state. That's number 2 is a true statement. Number 3 is a true statement, has to been in business for at least 5 years continuously. That's true statement. And number 4 is true, have to demonstrate financial strength, liquidity, and have to have a bond to back up the promise for at least $100,000. So last 3 are true. Number 1 is false because that would be silly. The employer has financial hardship, so we want to self-insure. No, that would be crazy. All right. Number 8, which the following is true regarding work comp in Utah? Okay, lots and lots and lots of right answers. Yep, so if you're ever trying to remember this, or if you have somebody that's going to be taking the property and casualty exam, remember the 2 C's, compulsory and competitive. Utah has compulsory laws, which requires most employers to buy work comp for most employees. And it's a competitive market. Employers can buy insurance from any company that sells it. And which of the following statements is not true about WCF? It used to be called Workers' Compensation Fund. Now it's WCF. Which one is not true? All right. So working up from the bottom, yeah, WCF is the insured last resort. Number 3 says it's required to write all work comp insurance, which application is made. That's true. Any employer who applies for insurance has to be given the insurance. But as we talked about, if there's more risk for a particular employer, the insurance company, including WCF, is allowed to charge an appropriate premium to reflect the risk. And number 2 is true. Employers that are high risk and are unable to obtain insurance from other carriers can purchase it from the WCF. That's true. And as we talked about, it is not owned by the state of Utah. It used to be long time ago, but now it's considered to be a mutual insurance company, not a private insurance company owned by the state. All right, comments, questions? Is there anything we missed from the chat regarding questions or comments?
Nope. Nothing in the chat, just quiz answers.
Gotcha. Thank you, Doug. Appreciate it. All right, we're going to take a quick little break, just a stretch break for 5 minutes. So we'll come back at 11 o'clock. All right, welcome back. All right, did anyone think of any comments or questions?
No.
Okay. All right, so what I'm showing you here is from the Utah Labor Commission, the Employer's Guide to Workers' Compensation, and has lots of excellent information. One thing that I think is really awesome is that they have this tool here for workers' compensation coverage verification. So if you are an employer and you want to make sure that everything is square with the state as far as your work comp policy, you can come out here and check your own work comp policy, make sure it's been registered with the state by your work comp insurance company. Or if you want to check that somebody who's hiring you has work comp insurance, you can come out here and do that. So and you can search by employer name, by their federal employer identification number, the FEIN, or address. So for example, if I put in Mountain CE, there we are. So it's verifying here that this company has work comp insurance that's valid, that's effective, that's currently active. And if I click on it, it just gives me a little bit more information. It also has a nice summary of the different benefits. Oh, before I go there though, I just wanted to mention also it has information about work comp coverage waivers. So this would be a situation where there's a contractor, for example, maybe just only one employee or only one person, one man band or one woman band. And that one person that has a business can either buy work comp insurance or elect to not buy it. And if somebody is hiring that contract worker to do some work, then the one who's hiring the contractor, remember, has to either provide work comp insurance for the one who they're hiring or verify that the contractor has work comp insurance or doesn't want it. Okay, so the one who's hiring can either provide it, either verify that company, that contractor has work comp insurance, or that contractor can apply for a waiver. And it's $50 to apply for the waiver. Okay. All right, so now here's the list of benefits for injured workers. So there's 4 main benefits, only 4. Work comp will pay for medical bills for injured workers. It pays indemnity, also known as disability income, for loss of wages. It pays a death benefit if the injured worker dies due to an injury or work-related illness. And so there's also rehabilitation is another benefit that can be. So there's 4: the medical bills, doctor bills, hospital bills, disability income insurance, also known as indemnity, the death benefits to the family, and also rehabilitation so that the worker can get back to work. Let's go into more details on these. So medical care expenses that are reasonable and necessary to treat an employee's injury or illness. This includes visits to a treating doctor, hospital bills, medicine, and prosthetic devices. It includes reimbursement for the cost of mileage to travel to receive medical treatment. Medical benefits are considered a lifetime benefit as long as the medical treatment is necessary to continue to address a work-related injury or illness. Indemnity, also known as disability, when a worker is injured, each missed day of work represents lost wages. In work comp insurance, indemnity benefits are paid to the employee to help them cover their loss of income. Payments are a portion of the worker's average weekly wage and take into consideration the extent of the disability. So when it comes to reimbursement for loss of income, it's usually, not always, but usually 66 2/3% of a worker's lost wages are going to be reimbursed. Again, that's not always the case, but in a lot of cases it is, about 2/3. So it pays a death benefit when the death of the employee is a result of a work-related injury or illness. Weekly dependent compensation is paid by the self-insured employer or insurance carrier to surviving spouse and or dependents. If an employee dies from work-related injury or illness, workers' compensation will pay up to a certain amount for funeral and burial expenses. It's not a lot. I think it was, what is it? It's under $10,000. I can't remember the exact amount, but it's not a ton of money. The insurance carrier or self-insured employer may request that the dependents supply copies of marriage, deaths, birth certificates, and also relevant divorce decrees as part of the filing claim. And then when it comes to rehabilitation and being able to get back to work, an employee can return to work after treating doctor releases the employee to light duty or full duty work release. If an employer accommodates suitable light duty work, the employee is required to accept the work or risk losing their temporary disability compensation benefits. If an employer cannot offer light duty work to an injured employee, the employee will be entitled to continue to receive temporary total disability benefits until the treating physician determines they are medically stable and able to return to work. All right, that's some highlights there. Any comments or questions?
Yes, we've got one. Can workers be covered by two policies? I'm assuming not.
I believe that that's not possible. Yeah, I don't think that, I've never thought of that, or I've never heard of that coming up, but I don't think that that's possible. I'm an expert at my opinion, and in my opinion is no. No. Only one work comp policy at a time. Thanks for asking.
So,
go ahead.
Tim also says apparently WC will pay for the duration of the employee's injury. I have a couple of clients who've been on WC for years, ?
Yeah, they can last for the rest of a person's life. So like, are you talking about like disability income, like loss of wages?
Tim, you'll have to clarify that. Sid Haycock says the benefit for death is $12,500.
Oh,
Craig Pendleton says DI policies coordinate with other plans.
yeah, they do. And it's my understanding that work comp is primary. It pays first. And then like if there's private disability insurance or there's additional like group disability or individual disability insurance on top of the work comp, then those plans pay second.
Okay. So Tim Croto did respond, says they have limited, his clients who have been on WC for years have limited ability to work.
Yeah. So there's, there's permanent disability and then there's temporary disability. So if someone is on permanent disability, like suppose something falls on my head in the factory and now I'm going to have permanent brain damage, I'm never going to be able to work again. Yeah, that can, benefits can last for the rest of my life. All right, did that answer any questions?
Seems to have covered it.
Oh, okay, very good. All right, now let's go back over to here. So get into more details about the benefits. I'm going to make a note of the 12,500. So it used to be like 6,000. One moment. Okay. Just seeing if I can find that real quick. All right, well, that's coming up. So we need to be able to differentiate between accident and disease. So we know what an accident is, but we know what a disease is. But in order for work comp to cover disease, we have to follow the state's definition of an occupational disease. It's any disease or illness that arises out of employment and is medically caused or aggravated by that employment. So, for example, let's suppose that a hospital worker gets a bad case of COVID, and would that be considered an occupational disease, do you suppose? Just a simple yes or no. Somebody gets COVID and they think they got it through work at a hospital. Would that be considered a occupational disease? Yeah, some of you are saying yes and some of you are saying no, about half and half, I think. Well, in my opinion, again, remember I'm an expert at my opinion, I would say no. Because how are you going to prove that you got COVID through work? You can get COVID anywhere, right? So I would say probably not. So anything like the flu, COVID, things like that are probably not going to be covered by work comp. But let's suppose that I'm, working in the hospital, helping out with a surgery, or maybe I'm doing the surgery and I get a needle poke or a knife cut and I get a bad infection. That would be probably, I get sick, get a staph infection, get hepatitis, and it could be reasonably traced back to the cut or the poke with the needle. Yeah, that would be covered by work comp. And things like, working in a factory and where there's asbestos and getting asbestosis and mesothelioma, it's a hard word for me to say, the disease you get from asbestos. Yeah, those are things that are covered by work comp. All right, we talked a moment ago about the summary of the benefits. And here they are again: medical care, rehabilitation, disability income, also known as loss of wages, death and survivor benefits. So it's important to know that work comp does not cover things like pain and suffering. And that's different than a lot of types of liability insurance. Like if you and I get in a car crash and you're hurt and it's due to my fault, my insurance policy can pay for your medical bills and so on and so on. My liability insurance could also pay for your pain and suffering. But work comp doesn't pay for pain and suffering. No extra money is awarded due to somebody having a backache or a headache or can't sleep and so forth. And so the treatment to overcome those things is covered. The medical care is covered, but there's no reimbursement specifically for pain and suffering. Punitive damages are not covered by work comp. All right, so if an employer gets penalized by a government for having unsafe working conditions and has to pay a fine, that's not something that would be paid by work comp. And also anything related to preventive care, not covered by work comp. A lot of work comp insurance companies, though, will provide like safety training and things to prevent things from happening, but it's not officially part of the work comp policy. Right, let's go into more details on the medical care. It's going to pay for necessary reasonable medical care results from bodily injury by accident that occurs during the policy period. Also, bodily injury by occupational disease caused by aggravated by the conditions of employment. Okay, so sometimes then the question becomes, what's covered by work comp or what's not covered by work comp? So I'll give you some scenarios here. Suppose that working in Clearfield, Utah, and I arrive at the job and it snowed and it melted and now it froze and there's ice in the parking lot. I arrive in the parking lot at my employer's place. I get out of the car. I'm walking from my car to the job, to the building, my employer's building where I work. I slip and fall and break my hip. Is that covered by work comp, do you think? Covered by work comp or not covered by work comp? Just a simple yes or no. What do you think? Okay, a lot of you are saying yes. And again, I'm an expert at my opinion, and my opinion would be yes. I think it would be covered by work comp. Because why? Because I'm going to the job. What about if I got an accident on the highway before I got to my place of business? Before I get to my employer's place of business, I get in a car accident. That be covered by work comp? Probably no, probably not. But what if I got to work and then I need to go visit a client? I'm driving to visit a client while I'm on the clock. Get hurt? That be covered by work comp? Probably yes. Probably yes. What if it's break time and me and a couple other people in the office are playing football? We're goofing around and get hurt. That be covered by work comp? Get hurt goofing around. And the legal term for that is horseplay. It might be kind of an iffy situation.
Okay, I'm sorry. Is the legal term really horseplay?
I think so. I looked it up last night. I was debating whether I should use the word horseplay or not, and yeah, it is a legal term for goofing around. So again, it's break time. I'm goofing around at work, get hurt. Based upon my opinion, I would probably say no. Because horseplay, doing something that the employer didn't want me to do, would probably not be covered if I get hurt. But what if it's a company picnic and there's let's say a sack race or something like that, or volleyball that the company sponsors at the company picnic, and I get hurt playing volleyball, that probably would be covered by work comp, because participating in a company sponsored activity. And so it's a gray area on a lot of these things, but just kind of in general terms. So here's another scenario. What if I'm sitting at my desk doing my job, and then my coworkers are involved in horseplay, goofing around, and somebody throws something, a ball or a golf ball, something over my cubicle, it hits the light and drops down, hits me in the head or something, or deflects somewhere, hits me in the head, and I get hurt as an innocent bystander due to horseplay. Is that covered? Yeah, that would be something probably covered by work comp. So it gets kind of interesting, like which things are covered by work comp, which ones aren't covered by work comp. And sometimes people feel like they've been hurt due to something that should be covered by work comp, and they file a claim with work comp and it's denied. I do know one thing that is denied. If somebody shows up drunk or under the influence of drugs and they get hurt at work, that's typically denied. All right, some interesting things there. Work comp does pay for rehabilitation. It'll pay for physical therapy, psychological therapy, occupational therapy, evaluation of physical and mental abilities, and career counseling. It'll pay for training to regain the skills needed to return to work. It'll pay for vocational training to learn new job skills, and the travel cost to and from rehabilitation facilities is covered by work comp. Okay, we talked about disability income, also known as loss of wages. I mentioned earlier, it's typically 66 2/3. In other words, 2/3 of the employee's average weekly wage at the time of injury. However, there's minimums and maximums, so it's not always 66 2/3. So when it comes to disabilities, there's four different categories of disability. So there's a temporary disability and permanent disability. We know what the difference of that would be. And then there's partial disability, like where a worker can still work and still make some money after the injury or illness. And then there's total disability, meaning unable to work at all. So here are the four categories. If we mix and match those different variables together, then there's temporary partial disability, where compensation is paid if the worker is still able to work, but the injury or illness prevents the worker from earning a full regular wage at the time that he or she is recovering. So suppose I'm a factory worker and I break my arm and I can't do the same job I was doing before, and I have to go on light duty, and I'm not going to get paid as much during that time, or maybe I normally am able to work this many hours, but because of my disability, I can only work half the time. So that temporary partial disability can be reimbursed. A portion of my income can be reimbursed. All right. And then there's temporary total, which means that the person is unable to work at all, but it's going to be a temporary situation. So like I fall off a ladder at work, I break both of my legs, and now I can't work at all. I can't do that job at all with two broken legs. But I'm going to eventually heal, get better. I'll be able to go back to doing the same job I was doing before. That's temporary total situation. Permanent partial is often associated with loss of a limb or loss of an eye, right? So my arm is gone in the factory. I'm never going to be able to get my arm back, and I'm never going to be the same again because my arm is gone. I can still do other work, but I'm going to get paid less, and that would be permanent partial. Permanent total is the worst kind, where, again, I got permanent brain damage, never, ever going to be able to work again, and I can get benefits for the rest of my life, disability income benefits for the rest of my life, or at least for a long time. Okay, any comments or questions there? I think I saw, Doug, that somebody had referred to a state law.
Yeah, I'm just taking a look at it here. I'll just read it out loud as I'm looking. Gene says workers' compensation insurance does not cover all accidents on company property, but rather only those that occur within the course and scope of employment. It covers injuries arising from work duties, even off-site, but generally excludes commutes, horseplay, self-inflicted injuries, or accidents during illegal activities or policy violations.
There you go.
Sid Haycock then says illegal is the operative term.
Yep. Yep. All right. So, and we did see that highly technical term horseplay there.
Yes.
All right. Cool.
That tickles me for some reason.
Yeah. Yeah. Like, and if you're a horse lover, maybe you think that's unfair. Like horseplay is bad, or shouldn't have benefits for horseplay.
I kind of imagine when they came up with that term that farm boys used to get out and race horses before they raced motorcycles, right? And they'd jump fences and fall off the horse because their dad made them ride bareback or something.
Yeah. Good analogy. All right. So when it comes to partial disabilities, there's what's known as an impairment rating. So a medical impairment rating is something that's determined by a doctor, a physician. It's a number between 0 and 100. So a lower number means less impairment. A higher number means more impairment. So 100 would mean I can't work at all. So the impairment rating determined by the doctor is going to allow the worker, the employer, and the insurance company to all understand how much the person has been injured and how much impairment will affect the work. Impairment rating helps determine how long an injured worker will receive benefits, how much compensation might be received, and whether the worker is expected to return to work in the future. Okay. All right. So, and then when it comes to death and survivor, I had for a lot of years, it was $9,000, and I hadn't been made aware that it has changed, but I'm going to verify that has changed because someone had said it's now $12,500. If that's the case, I'll have to update my materials. So in addition to that one-time death benefit, there's also an ongoing payment that can be made to the survivors. So that's called survivor benefits. And so it's going to be a percentage typically of the deceased worker's weekly wage at the time of the injury. But there's extra money for each dependent child under 18 up to a maximum of $100 more per month. And survivor benefits normally end for a surviving spouse upon remarriage. For a dependent child, the benefits end upon reaching 18 or graduating from high school, whichever is later. Okay, let's do a few quiz questions where you can participate. Which following is an example of a death survivor benefit that must be included in work comp policies? 1, 2, 3, or 4? All righty. All right, looking at your answers coming through. So not all of you are agreeing on the right answer. Let's go through them. A lump sum of money that's 3 times the yearly salary. No, that's not. Number 1 is not true. Number 2, counseling services. I think that's true. Number 3, a weekly income for the spouse and children. I don't think it's weekly. I think it's monthly, if I recall. And a lump sum equal to the yearly salary. The last one is not true. Pretty sure it's number 2. That does include, nope, it is the weekly. Oh, I'm sorry. I messed up. So it is a weekly income. Counseling services are not provided. I had forgotten that answer. What is another term for disability income? Yep, disability income, also known as loss of wages, kind of associated with Las Vegas, loss of wages. Number 3, work comp can pay for which of the following? All right, work comp, of course, can pay for rehabilitation. So the things that start with a P aren't covered by work comp. Punitive damages aren't covered. Preventive care, not covered. Pain, suffering, not covered. What is the dollar limit specified in the work comp policy of workplace injury? Okay. Who thinks they know the answer for sure? Who's willing to put big money that you have it right? Somebody has offered 50 cents. Willing to put up 50 cents? Anybody who's willing to bet the farm? I'm not sure if we got any takers there. But the answer is there's no limit. There's no limit specified in the policy. So remember I said earlier that a work comp policy is very simple. It's very short policy compared to a lot of other policies. It doesn't have like limits of insurance. Well, it does have employer's liability, which is a different matter. But as far as like what's going to be paid for medical bills or disability and so on, it doesn't specify any dollar limits. Those dollar limits are specified in state law. So when somebody gets hurt and the claims adjuster has to determine how much is going to be paid, the claims adjuster for work comp is going to refer to state law to determine how much will be paid. There's no limits specified in the policy. What term describes any disease or illness that arises out of in the course of employment and is medically caused or aggravated by employment? All right, a lot of you are saying number one, occupational disease is correct. A work comp policy can pay disability income compensation to reimburse the injured worker for loss of wages, and it's normally how much? It's normally about how much? Yep, it's normally 2/3, more specifically 66 and 2/3%. Sophia was in an accident and she lost the use of one leg. Although she can work now, she'll never be able to earn as much as she did before the injury. What type of disability is that? All right, so the leg is gone. She can't use it anymore. It's never going to be completely fixed. So that's going to be a temporary situation. I'm sorry. It's going to be permanent and partial because she can still work, but her situation is a permanent thing. So forever, she's going to be earning less than she did before. Work comp can pay for which of the following? Yep, it could pay for disability income. Okay, Alex fell off a ladder at work. broke both legs and his hip. He could not work for several months while he was recovering. He eventually returned the job and he had before the injury occurred. This is known as which type of disability?
Hey, John.
Yo.
This is Sean Bitter. I have to head to a meeting, but I can finish the call if I join in on my phone. I'm in the waiting room if someone can let me in so I can finish the questions. That'd be awesome. Thank you.
All right. Doug, are you able to do that?
Yeah, I'm just not seeing him in the waiting room.
It's shbitter@gmail is the email address on that profile on my phone instead of my work email address.
Yeah, I just don't see anything to saying admit you or anything. So Sean, if you'll work with my colleague at the we'll figure out how to do this, even if the technology is not working for us right now, we'll figure out how to get you so that you can do the questions and everything. Okay.
Okay, thanks.
Doug, sorry to interrupt. I just admitted him. For some reason, it just popped up again. So, Sean, are you in?
Okay, I got it.
Awesome.
Okay, so thanks for doing that. So Alex fell off the ladder, broke both the legs and his hip. So this is going to be a temporary situation, but while he's recovering, he can't go to work at all. So this is a temporary total situation. Which rating helps determine how long an injured worker will receive benefits, how much compensation might be received, and whether the worker is expected to return to work in the future. All right, that's called, of course, an impairment rating determined by a physician. While Russell was working at the beach, a coconut fell down from a tree, struck Russell in the head, and left him with a tragic brain injury. Russell will never work again. What kind of disability is that? All right, of course, that is permanent total. And the thing that inspired me to write that question was my wife and I were in Hawaii a few years ago, and there was there was a path along the beach, and there was a whole bunch of coconuts up in the tree, and right above where people were walking. I thought, well, that's kind of dangerous. Like, one of those things fall off and hit somebody in the head. And there was a whole bunch of other ones like laying around along the path. And I thought, that's dangerous. It's an accident waiting to happen. Eddie was hurt at work on Monday, went back to work on Tuesday, but his earnings were reduced for 3 weeks because he couldn't work as much while he was recovering from the injury. This would be considered which type of disability? And of course, that is a temporary partial disability. And so I want to circle back to the burial expense. if a worker dies while working or due to a workplace injury or disease, yes, it has increased to 12,500. So appreciate you mentioning that, because I will update my materials. It increased about a year or two ago, it looks like. So thank you.
Now, on the first question in this set, talked about the death benefit, and the correct answer was something like multiple times his yearly wage. So how
Yeah.
does that correlate with the
Oh.
$12,500? That didn't make sense to me.
Yeah, those were wrong answers. If it said like something about like 3 times the wage, those were wrong answers.
But there was not the right answer according to that. I don't know if you can go back to the question number one. It probably doesn't matter, but I was confused by that.
Yeah, I'm saying that, if it said 3 times the wage, that's wrong answer. And so there's only one right answer for these questions. Let me see if I can find that. So it's like, for example, here, this one was, what is a example of death benefit? So the first one, 3 times yearly salary, that's a wrong answer. That's not true. The last one, a lump sum equal to yearly salary, that's not true.
But a weekly income for the spouse and child is the correct answer,
That's right.
isn't it? But
Okay.
that
I see.
doesn't correlate to the.
Oh, I'm sorry. I see what you're saying. So yeah, there's when a worker dies to a workplace injury, there's 2 different types of death benefit. There's the one-time lump sum death benefit now of 12,500. In addition to that, there's a weekly income for the spouse and children of the worker. So there's two different things.
Thank you. I didn't understand that. I appreciate that.
Yeah, thank you. Appreciate you asking. All right, very good. Any other comments or questions? All right, now this should be popping up. We went through all that stuff. Oops. All right, here we go. What are the 4 main benefits provided by work comp to employees who suffer work-related injury or illness? So remember, you never know which questions you're going to get after class to determine whether you were in class or not. So what do you think the right answer is there? 1, 2, 3, or 4? This question is so easy, even I could get this one right. Excuse me a moment. The answer is number 1, medical care, rehabilitation, disability income, death and survivor. So that helps us to see the way the death benefits work, is that there's a death benefit, a lump sum death benefit. In addition to that, there's benefits paid to the survivors, surviving spouse and surviving dependent children. Okay, awesome. Now let's go on to policy parts. So there's 6 main parts to work comp policy. And part 1 of work comp policy pays the benefits required by state law. And it works pretty much the same way in all the states, even though each state has their own variations of the state laws. But most states, including Utah, cover 4 main benefits. There's medical care, rehabilitation, disability income, death and survivor. So he's mentioned that a few times already this morning. And so work comp policy says that this policy pays whatever state law says it has to pay. And the details of what the limit is and for how long our benefits going to be paid and how much and everything, that's all specified in state law. Part 1 of work comp policy just says this policy pays what state law says that we have to pay. Part 2 of a work comp policy is called employer's liability. And it covers things that are not specified in state law. So traditionally, work comp policies have always covered two main parts. Work comp policies will pay what's required by state law, part 1, and also pay for employer's liability. It's for rare situations where an employer gets sued due to somebody's workplace injury. Doesn't happen very often. So part 2, employer's liability, is there just in case, as a safety net in which that could happen. Because remember, if I get hurt at work, I don't have to sue my employer, and pretty much I can't sue my employer. So you might think, well, what's the point of employer's liability then on a work comp policy? Well, there's 4 examples here, or 4 situations that are highlighted here in which an employer could maybe be sued. I'm not going to mention all 4 of them. I'll just give you the middle 2 because it'll serve the point. Number 2 says loss of consortium. A family member sues for loss of affection and services. So before I got hurt at work, before I suffered this horrible head injury at work, I was kind of an okay guy. I usually was nice to people, and I got along with people, and I was pretty much nice to my family. But before, that was the way it was before. But after I got hurt, I've turned into a monster. I'm really mean to people. I'm ornery. I'm mad all the time. I hurt people. And so my family, my wife, maybe the kids, can sue my employer for turning me into a monster because I suffered this injury at work. So that's called loss of consortium. It's possible that those types of claims could arise. Another example is consequential bodily injury to a family member due to the employee's injury. So suppose I'm working in the factory, I get hurt really, really bad, and my employer calls up my wife and says, hey, hi, Marlene, this is so-and-so at John's place of work, and just to let you know, John got hurt really bad, and he's almost dead. And my wife, I'm thinking, would have kind of a surprised reaction and an excited reaction, and be maybe upset by the news, and maybe she suffers a heart attack because upon hearing the news, maybe. And so because I got hurt, my wife got hurt, and now maybe she can sue because of my workplace injury. So kind of these types of claims don't happen very often, but sometimes they do. And work comp always comes with all kinds of liability insurance, of course, comes with a duty to defend, right? So even though maybe the suit will be successful, maybe it won't be, but my work comp insurance policy has to provide me with the defense, has to address the situation, figure out what to do, how to proceed forward with it. All right, so again, remember there's 2 main parts, work comp policy. Part 1 pays what state law says the policy has to cover. Part 2 is extra liability protection, just in case an employer were to be sued for workplace injury, which doesn't happen very often. Now I'm going to skip down to another really important part of the policy, which is Part 5 premium. We touched upon this earlier. So the annual premium is calculated at the beginning of a policy period, and work comp policies are a year long usually. So the work comp insurance company is going to estimate the premium at the beginning of the policy. So I'm going to go through an example here. Suppose that it's a construction company and there's 2 types of workers. This construction company has office workers that sit inside in a comfortable air-conditioned room. In the summertime and wintertime, it's heated and it's controlled conditions, and office workers, of course, have a low chance of getting hurt. But this construction company also employs construction workers, which have a much higher chance of getting hurt. So for all the different kinds of employees with a particular employer, we're going to calculate the premium. So the lower the risk, the lower the premium, the lower the rate, I should say. And then we take that rate times the annual payroll for all the workers that fit into that category. And then we divide it by 100 because the rate is a rate per $100 of payroll. So doing the math here, it only ends up being $500 for the office workers. Construction workers having a higher rate and a higher annual payroll results in a much higher premium. So again, we're talking about what happens at the beginning of the policy year. When the policy is about to start, the work comp insurance company will calculate the premium for each worker, each type of worker, I should say. Add up the premium for all the different types of workers, and then that premium is then multiplied by an experience modification factor, or experience mod, or mod factor. Different insurance companies call it different things, but it's a reflection of the risk of the safety record of this particular employer. So 1 is average based upon statistics that are gathered. The rating bureau is going to determine an expense modification factor. If it's less than 1, that's good for the employer, because that means they have a safe work record, and they're going to pay a lower amount for their premium because the experience modification factor has an effect on the premium. If this employer has had a bad safety record, lots of people have gotten hurt, filed work comp claims, then that's going to increase the premium. So that's what happens at the beginning of the policy period. And then at the end of the policy period, a work comp audit is done. The work comp insurance company is going to contact the employer and say, what was your actual payroll for the last year? At the beginning of the year, we estimated the premium for that year. But now at the end of the year, the work comp insurance company is going to want to know what is the actual payroll for the last year. And then the premium is recalculated using the actual numbers, the finalized numbers, and that's going to arrive at a final premium. And then the work comp insurance company is either going to issue a refund if too much premium was paid in at the beginning of the year, or they're going to send a bill for the additional premium if the final premium is higher than the estimated premium. And so work comp rating premium calculation is very simple. There's sometimes a little bit more to it, like if the premium is over a certain amount, then it might get discounted a little bit. And then there's terrorism insurance, which is a required thing on work comp, but this is about 95% of it right here. That's how work comp insurance premium is calculated. It's very simple. All right, we're going to wrap things up here. Any final questions or thoughts, Doug? Oh, yeah, so remember, just in case you were to get this asked in one of the polling questions, what are the factors that determine the work comp premium? Well, it's the rate based upon the type of work that each worker does. It's the payroll that's a factor in the premium. And then also the experience, the history of that employer related to work comp claims. Those 3 things determine the work comp premium. All right, Doug.
Okay. Kirsten, Morgan, who's doing the, Kirsten, are you doing the polling?
I did post the polls. So if you have any questions about them, let us know. If you weren't able to answer them, and if you have to leave, please let us know and we can email them to you also.
Thanks, everybody. Appreciate you being in class.
Oh, thank you so much, John.